There are a number of recent trends that I'd like to talk about. The first is jurisdiction, the second is privacy, and the third is cryptocurrency and blockchain. The thread among each of those is that courts are really trying to grapple with new technologies and how those new technologies are pushing the law. In some senses, courts may revert back to previous case law and try to analogize back to existing frameworks, and in other cases courts are trying to understand how new technologies push the envelope and require them to think of new ways to address new legal problems. And the first example of that is jurisdiction, which I know sounds like a very technical legal argument, but when you think about it, where you're having your fight and what the procedure is are really the most fundamental parts of litigation. And we see that that is really a big battleground area in a number of litigation cases involving online activity before there's even any decision on the merits and the case can proceed on what's really an issue. It also leads to important questions of enforcement and whether Canadian orders will then be enforceable in other countries. And so there will be, I expect, continued battles over jurisdictional issues. Where this is relevant to what companies can actually do about this, because in some cases you don't know who you're going to fight with and where they're going to choose to have the battle, but to the extent you're entering into contracts, contracts are one way to at least try to prescribe what forum or arbitration format you're going to use to resolve your disputes. And so giving serious thought to your arbitration clause or your jurisdiction clause and what might be enforceable in light of existing case law is really important so that you can make sure that you're having your fight where you want to have it. This, as I said, can become more difficult in the consumer context where courts are more likely to protect consumers and, in some cases, employees from draconian or harsh arbitration clauses. I mentioned jurisdiction as one of those areas, and the issue there is that Canadian courts are taking the view that they can issue global orders against companies that conduct business online and making sure that they know what laws they're going to be subject to. The key takeaway from this is, to the extent possible, where you're entering into contracts, even if they're online contracts, trying to make sure that you're prescribing the jurisdiction or arbitration format, if you choose, that suits your interests. And the way to do that is through your jurisdiction clause or your arbitration clause.